Do we have everyone here? The word of the day is maybe. That's our theme for today. Maybe. There's a whole lot of maybes. Welcome, everybody, to Barely Interesting episode 13, where we are graced by Saul's Cave Troll. What?
Yeah, because I'm usually behind the scenes. I'm just like stuck in my little basement cave typing up reports and stuff while he's doing all this stuff. So
I see. Well, welcome, Jen. Welcome to the show. Is this your first time on camera?
Yep.
Nice. I'm glad it was for this, and not anything dirty. So we
I didn't say no to that.
we had a long stream today. We thought it was appropriate to combine the last 2 days, and then with the closing arguments and the sentencing, the verdict, I should say, and the sentencing. It was a tough case. Or a day, rather, I should say. I saw a lot of people in the chat that were like, "Yeah, this kind of sucked." It sort of brought it all back again, and so it was a tough day for everyone. But we do have a lot to talk about today, and we might go a little long. You're welcome, Jung. But we have Dan the Man that first testifies. Then we have Luke Skywalker. We have Jill O'Halloran. I don't know how you say her name. We have the accountant, and then we have the firefighter. And then we're back to Anschutz. Wait, are we back to Anschutz?
Anschutz didn't testify.
Nope.
We had.
Yeah. We had two statements
from the other rebuttal witness, which is the CO from KCDC.
Yes, thank you very much. Yep. And so that's all the witnesses we have for the rest of this case. The more and more I rewatch this, the more and more disappointed I am in the the defense's case in chief. Mainly because I feel like they could have done a lot better with a lot more witnesses and mod me Vahalas. But let's start off with Dan the Man first. So Dan the Man was the first defense witness to testify on day 14. And he testified to have searched around the apartment, Rosalio's apartment, searching the dumpster. I think he talked about a drone flying over and things like that. Said he didn't find a rug. He didn't find Rosalio. He didn't find a flannel, Zach's flannel, missing flannel, which I don't know what the connection was there. I could see if they had surveillance video of a guy in a flannel, but otherwise, I don't get it. He had a flannel, and now he doesn't.
Okay. Yeah, it was another loose end that they never wrapped up. They just made reference to the flannel that he was wearing on the 17th, but then nothing ever came of that. They never found it. They never even said that they didn't find it. They just let it go. You're just supposed to assume he was wearing it.
It's a lot like, a lot of things that are brought up in this case. They just sort of like throw stuff out there and then don't follow up with it at all.
There's a lot of things, especially in today's stream, that they just assert as fact without ever presenting an iota of foundation or evidence to present it, and it's pretty consistent actually with Kenosha DA in this in especially today in the closing argument and in some of these witnesses. I mean, he got a little bit of foundation where he brought 2 rebuttal witnesses, but we'll get to that in a bit. But Officer Bandy, for the most part, was just like, he was brought on to be like, did you ever find a body? And then he goes,
Nope.
"Oh, I sure didn't."
Nope.
They're like, "Did you look into anyone other than Mr. Anderson?" He's like, "Nope. I
Negative.
just did what I was told."
And the other thing too is that he testified. Wait, hang on, I got the right one. No, that's Sean. Wow, Sean and Dan look alike. That's all I got to say. I was looking at Sean from testimony on day 9, and he looked like Dan. But the other thing he said is that they're not looking for Rosalio. They haven't been looking for him for a number of years, it seemed like, before he testified, which is interesting. I mean, I'm not sure it helped the defense, but it sure looks a little shady from the investigation end of things, right? And that's the whole defense.
I will say that assertion, the fact that they got him to admit on the stand, supports the defense's case in chief, which in the opening statements was that the police didn't bother. And so when they're saying, did you continue to look for Mr. Gutierrez? And he says, well, no, why would we? He's missing. And I'm
why would we?
Why would we do that?
He's not missing. Well, okay, but assume he's dead. His body's still missing. You kind of want to find that, right? You would assume, bring some closure to the family. Well, specifically, he testified is, I don't know if anyone's looking for him, is what he testified to, which seems to indicate. And he also said that if they were looking for him, he would probably know. So, so that's about it that we got from this guy. Not a big win for the defense. And it's one of those where, okay, you could start seeing things chip away, but like the state had, I don't know how many witnesses, 13, 14 witnesses, something like that. I might be off on the number, but they each chip away at the defense, right? And now that it's
come
the
on,
defense's
David,
opportunity.
They brought 4 witnesses just for Walmart videos. I think it was much more than that.
True. But anyways, my point being is that the defense could chip away at some of these points, but they really didn't have enough witnesses. They didn't have, and Solomon should have testified. That's all I'm going to say. But next we have Luke Skywalker, firefighter.
No, he's a police officer.
Oh, police officer. I'm sorry. That's right. We're not to the firefighter yet.
Not yet.
So he testifies. Yeah, he's the fashion police. That's right. He took Zach's clothes from the police department. My notes from today are, oh my God, he has new clothes. Who would have thought that someone would buy new clothes? I thought that was Solomon. Okay.
It's not. It was the husky coming to woo woo.
So, but again, nothing really significant other than there was no stains, there was no marks, even on his underwear. They were stain free, folks. But
no, there was one small yellowish stain on his t-shirt.
Oh yeah, that's right. But
better
nothing of significance.
True.
But nothing of significance. No stains of significance. That's how the question was asked.
But 2 different size flip-flops.
That's so weird. I remember that.
And you can see they actually show Zach's face when he says one size 11, one size 12. The camera switches to him in the live feed, and you can see him go, huh? Oh. He had no idea.
And he always wore them, right? He always wore flip-flops.
All the time.
Yeah,
all the
that's
time.
Great.
He wore flip-flops while roofing my dad's house. Like, this is how tethered to foot.
So do you know? Oh God.
I don't know why you're yelling at me on stream.
Moving on.
Now, after this witness, the defense had planned on calling 2 more witnesses. Those 2 witnesses were who were they again? I can't remember. Anschutz and
They actually didn't name the other one. Anschutz is one witness that they wanted to call.
Name them. They did name them. I just don't remember what they were.
Are you sure that? Well, Lauren Anschutz was one. Honey, do you remember the other one?
I have no idea who the other one is. I don't know that they ever named the other one. It was another officer, I think, but
I believe that it was an officer, Morrissey.
Morrissey?
I think
But he had the
Gravely
flu?
named him and said that he was sick.
Mm.
But anyways, they weren't available. Now on Schutz, however the hell you say his name, he was there the entire trial, and yet all of a sudden, when there's a subpoena issued for him to testify for the state, he just disappears.
Yep.
Um,
He was back for verdict.
Yeah. He was back for verdict. Of course he was. How
2 days later.
mysterious of that.
Yeah.
Which we're gonna come to how the case resolves that issue, but because of that, the defense is without witnesses, and so this was slightly controversial that the defense or that the state is allowed to call this woman as a rebuttal witness out of turn. Solomon, what are your thoughts on this? You know, you seem to think that there's some sort of shenanigans going on.
I mean, I just disagree with this decision because it actually breaks up the defense's case in chief. And when jury is trying to piece together this argument, you're then inserting a witness for the state to rebut arguments made by the defense in the middle of the defense's case. And I understand that they're trying to maximize time and do things for the jury's time overall, but this witness didn't even need to go right now. This witness could have gone at the end comfortably with enough time left in today's day of court proceedings with no other problems.
Yeah, was she excuse me. Well,
yeah, she testifies to the location of the cells where Munch was housed. So like the time frame, it's really focused on the jail snitch and the fact that that the defense got this other witness, Nick McAtee, to then testify that the prosecution approached him to offer him a deal to help him get out of his federal charges. And this relationship, this witness is the prosecution crapping his drawers, trying to scramble to piece something together.
Yeah, I mean, the whole rebuttal is focused entirely on the jailhouse snitch, Mr. Washington, and the rebuttal of that. Thank you. And in honor of Valhalla, I got my Bud Light. But
I can see Valhalla wearing a dress. That makes sense.
Yeah. I believe there's a video out there of that. But yeah, so this woman here she's a custodian of records, and what that technically means is that she is like a record keeper, and you're allowed to call record keepers, even though they don't have personal knowledge, to establish foundation for business records or records that are regularly kept. So that's who they called. They called this woman. She doesn't have any personal knowledge of who was sleeping where on what day in the jail, but she has the records of it. She's the record keeper. She's allowed to testify to that. And that's essentially what she testifies to. But calling witnesses out of order is not terribly unusual. When you talk about judicial economy, that's the whole thing that the court's going to look to. We've got a bunch of downtime because we don't have witnesses available because of unforeseen circumstances. So we're going to allow the other side to call some of the rebuttal witnesses to fill that in, so we don't just have the jury sitting around or sending them home and bringing them back. It's called judicial economy, and that's what it is. You see it very often in bench trials or civil trials. Not so much in criminal, but you're still allowed to do it in criminal. I think I didn't see the defense putting up an objection to it.
They didn't.
So
they must have just stipulated to it. Otherwise, if they thought that this was a huge deal, they could have argued against it and said, no, this is going to break up our flow. It's our case in chief. Our witnesses are not available because they are the state and they just happen to be disappeared. That shouldn't then come back on us.
I honestly think that, we keep talking about some of the shortcomings of the defense, and this one is major in my opinion. I really think that the defense should have fought it. It was their case in chief. I understand that they're trying to respect the jurors' time and respect the court's time. But in the end, we still have to deal with, breaking up the defense's case and the narrative that they're presenting to the jury, which only creates more confusion, which only then undermines the strength of the defense's argument. And that's the bigger issue in my mind. especially because a life sentence is on the line in this. If it was something that was maybe a lesser charge or something like that, maybe I would be a little more understanding. But this is literally taking a man's life away.
No, it really is. And hopefully you can hear me okay. I was having camera issues, so I had to reset it. But I just, the courts are thinking about the judicial economy, the state's thinking about a win, the defense is thinking about we just want to make sure our statements get out there, and we're going to get into those in a minute. But there's a way to present things, and again, this is not a complicated procedure. Everyone should know everything ahead of time. Both sides should know who the witnesses are going to be, what the evidence is going to be, roughly what they're going to testify to. The defense didn't know what its own witnesses were going to testify to the day, on day 13. We talked about that with the neighbor witnesses. They had no clue what they were going to say. You could tell. And it shouldn't be like this. This is not how a trial is conducted. I've said it over and over that this is a pre-rehearsed production at this point. It's a song and dance for the jury. And that was not this case. They were sort of figuring out their way all the way through, and that makes for a bad case. Is it grounds for an appeal? Probably not. Not just that by itself. But again, it's one more thing. I think Steve Gosney said, he's like, you get this little thing here and this little thing here and this little thing here, and it starts adding up. And this is just
cumulative error.
Yeah,
right? So is it cumulative error on his representation? Is it cumulative error on the defense? Because you can argue that is an appealable issue. Some cumulative, ineffective assistance to counsel, and I think that there is an argument for that. But we have cumulative error by the judge, cumulative error by the prosecution. All of this poisoning the jury pool. On top of that, we have jurors that may or may not be admitting to have followed this case in the news and how they were very familiar with it. So they were already biased going into the trial, but the judge convinces them to say they do. So we have a witness that's through marriage related to a juror. So
yeah,
all of these things are problems.
Yeah. The issue is also, how do I want to say this? When you're an attorney, like a lot of people accuse me of steel manning arguments on YouTube and everything else, but you are trained to steel man arguments. You should be anticipating what the other side is doing, what they're thinking, how they're going to come, and cross-examine and argue their position. I watched this trial the first go around and I thought this guy's not innocent, but I'm not in the case itself. I think these defense attorneys might have been a little too confident in their positions, like this isn't enough evidence, and they weren't really pushing the issues that, seen in a different light, could be really damning. So I think that might have been part of the issue as well. Let's see here. So the next witness then is the accountant. You want to talk about?
So Connie talks about Zach paying his taxes on the 18th. So she recognizes the receipt. Now the issue is that she even cites that the secretary is the one that accepted the money that signed for this, but they didn't subpoena the secretary to show up and then, or the front desk person to show up and then testify after this. So this is good foundation. She recognizes the receipt. She recognizes the timestamp, but she's not the eyewitness that saw Zach's demeanor, what he was wearing, how he carried himself, if he seemed nervous, like any of those other pieces that could have been testified to in an interpersonal interaction with him from her own eyes as a witness. And so this is good that we have, this person testifying for Zach as an alibi on the 18th, but it's not enough. I feel like they could have done a better job bringing more to the table because, in the end, we talk about the strength of the argument, the counter argument, and they just sort of lean heavily on the idea that the state didn't prove it. And because the state, in their mind, didn't prove the case, they didn't go for the throat in this.
Yeah, they're arguing to juror members like me, but Obviously,
Right.
I wasn't the makeup of the jury, right? And so you've
Right.
got to be able to argue to all the demographics of the jury. The state didn't prove their case, but also here's all these different really good reasons why they can't prove their case and he's actually innocent. You can't just necessarily rely on the lack of evidence, which this case had a whole lack of evidence.
A
Hence
vacuum.
the theme today was maybe he burns a pair of jeans, maybe he burns multiple jeans. We're gonna get to all of that
Which,
nonsense.
I mean, that's part of Gravely's argument again, is that he leans more heavily into the lack of evidence means evidence argument.
Right. It means he destroyed it all. There is no evidence because he's that good. Not that we suck at our jobs or we looked in the wrong place, but he's just better than all of us. This
It was
one
a
guy.
perfect crime, except he got
Mhm.
caught. So yeah, so I mean, again, it's like little chips away, right? Little chips. But at the end of the day, they didn't really have. Again, it's cumulative chipping away, and they didn't really have that. So then we get to the fire chief. What about the fire chief? What do we want to say about the fire chief? Other than he testified that Zach had a burn permit. That's what's in my notes. I don't remember much else.
That's pretty much it. And then I know the state was questioning him on, well, is it legal to throw things like bleach bottles in your fire pit? And so, of course, he was like,
yeah.
well, no, I mean, that we don't recommend that.
Can you
But
burn steel toe shoes, Jen?
apparently you can.
So there was one thing that I thought was really interesting about his testimony that was then contradicted shortly after in recross, I believe, that he states that when he arrived with his rig, the fire was already totally out, that he did not have to perform any intervention on this described smoldering fire pit. And that struck me as odd, because they've testified over and over and over again that this fire was still hot or still smoldering in some way. But his testimony contradicts it completely when he
Well,
says,
and then it's addressed during redirect or cross, I think, by Gravely. Because at
Gravely,
some point,
that's what I said in recross or in cross or recross, Gravely brings it up and he asks him, like, and then he says, yes, we put the fire out. But that's not what he just testified to. And I don't think anybody really caught that. He testified that when he arrived, his own eyes, that the fire was totally out. He didn't have to do anything to it.
Yeah.
But then he goes on to say that they put the fire out. Those things are self-contradictory.
Now there's two stipulations entered because these two witnesses, Anschutz and the
You're
other
jumping the gun. It's the
sorry.
other witness first.
Who's the other witness?
The CO. The guy, the prison or the jail CO that
I don't have a picture of him. That's why I'm all confused. Yeah, okay. So then we have that witness testifying about the sound, about how it echoes, and about how there's a line that they can't cross the line, they can't go up to the cells and things like that. I don't think it helped the state. I think that was actually a fairly good defense witness at the end of the day, talking about how they could communicate, right?
I think so too. And I mean, he was questioned about the rules and what's supposed to be done, but then the defense did a really good job of saying, yeah, but not everybody is really strict about that. He said, yeah, that's true. There's a difference in how each officer, enforces the rules in the unit. And so I agree. It was actually really good for the defense.
That was probably one of the stronger defense witnesses, including the first defense witness, who was.
It's not a defense witness. It was a rebuttal.
Oh, I'm sorry. Yeah, that's right. You're right. It's a rebuttal witness. I apologize. Yeah, that's why it's not in my list. It's a rebuttal witness. But yeah, and then but yeah, it ended up being fairly good. It's right. It wasn't it was a state's witness. So I'm surprised with as good as it was then for the defense. And then we get to the stipulate, because that's the state's last rebuttal witness, right?
That was the second rebuttal, and maybe he went after they stipulated and read those two stipulations, because technically those were the defense's case in chief, and then
That's the order my notes are in.
So you're
Must be true.
You're probably right about that. I was thinking about it as we were talking.
It's an incorrect correction by Solomon here.
So my bad. Either way, we had the two stipulations. The first one was the stipulation. It wasn't offshoots. The first one was.
First one was the other guy, and he was talking about. Ooh, wait, hang on a second. Hang on. I wish I had like an intro song or something, but welcome, Zenith.
Hi.
Yay!
Hey.
Nice to meet you finally.
Oh, yeah. Nice to meet you. I feel like I know you. I mean, thank the babies.
So anything we talked about that you wanted to rehash and go over and rant about?
Me?
Yeah.
Yeah.
That we have enough time.
We need many more hours for that.
Yeah. I mean, anything that y'all talked about previously, like the because I don't know what's been talked about tonight so far. I was putting a baby to bed.
Oh, we were talking about how the defense, well, where we were right now is how the defense sort of kind of dropped the ball with the two missing witnesses and thought that they would get in two statements, and how that was going to be satisfactory. And I was just going to go into my little spiel about if I sat here and just read something to you, it's not that interesting. You're going to forget about it, as opposed to witnesses being on the stand.
Yeah, but we're
which
also
is just more
talking.
memorable.
Sorry, we're also talking about the detective that went and played or went to go watch his daughter's volleyball or something, right? Like he
I
made
think
some.
that was Outshoots, wasn't it?
It's
Yeah.
That was his excuse.
Yeah. So I think it's a lot. I mean, I think the whole thing's baloney, obviously. Like, what I couldn't even tell you what upset me the most. Sometimes I don't know, because I don't know. How do you pick? We've never been in this situation before, right? Who thinks they're going to be in this situation? So when you're picking a defense or you're looking for lawyers, you just don't really even know what to look for or how to know someone's going to be. I don't know. And I think it all kind of was, I wanted them to, like in the beginning, we didn't even know Nicole was a part of the firm. We had hired the two, and I had actually known people personally in the Sheboygan area that had Aubert as an attorney for just like legal things here and there. And he came highly recommended. So, we thought we were going into it strong. They were expensive as hell. So like, you think you get what you're going to pay for. And I don't feel like that happened. So
we were talking about a moment ago that one of the issues might have been that the defense was overly confident in the lack of evidence carrying the acquittal, as opposed to attacking what evidence there was.
Yeah,
because they were essentially preaching to me sitting on the jury, but obviously I'm not on the jury, and the jury wasn't thinking like me, that there's just a whole lack of evidence. And so
I also think that if you watch the trial, you know how many times the jury got sent out. So we watched the whole thing. We know all of the stuff that went on while they were out of the room. So we get a bigger picture than the jury ever got, in my opinion, right? So they don't really kind of know what's going on. Plus, who wanted to listen to Gravely just yell at you for hours every day? Like, I would have tuned that out so fast. Because he was just unbearable. And I mean, I don't know. I think that plays a big part into it. They didn't know what was going on. It's hard to keep up.
This is a good point. Demonstratives really could have helped. The 280-pound dummy.
That's what I said.
Writing down on a spreadsheet of the evidence. Yeah. All kinds of things, demonstrative wise, really could have helped. And there was no demonstrative evidence.
Let's be realistic about this. The states presented demonstrative evidence, or their story changed between opening statements and halfway through the case, every time there was a witness, suddenly their story warped from opening statements towards where we ended up today, where suddenly a man who was originally 280 pounds is now 220 pounds to one witness's testimony. We have other statements that are totally debunked, where they tried to assert that originally there was pounding at like 11 p.m., but now it's somewhere between 9 and 10, or between 10 and 11. So we have all these different time frames where, or maybe it was they were trying to present that it happened during the 9 o'clock hour. That was the state's original case, where they were trying to present, because Rosalio's last phone call was during the 9 o'clock hour. So they were trying to say that it happened during the 9 o'clock hour to give Zach enough time to do this and then get home. But then the witness says that the noises occurred between 10 and 11. So then the state, instead of saying, well, this is what the evidence said and this is what we believe to be true, changes their argument. And instead of sticking to the facts asserted, they then try to warp and change the argument by the end of it. The jury, after a 3-week-long trial, forgets the opening argument or the opening statement. They forget half of the issues with the trial in the state's case. They forget about the daughter contradicting herself from one sentence to the next while on the stand. They forget that Sadie is hostile, that she's evasive, and that she's clearly also contradicting herself. So they conveniently forget all of this because Gravely kept presenting irrelevant and other acts evidence, trying to get more and more people in to make it seem like a very big case. But the reality was that it wasn't. It really wasn't. They didn't have that much. They had stuff that they tried to present as circumstantial that had no connection to Rosalio's disappearance. It was exceedingly weak circumstantial evidence. And that is what he rides his coattails on. And then he lies to the jury repeatedly.
Yeah. What thinking about a strategy, right? You always want to come in with a theme that you focus. We've done our themes on this show, right? Today's theme is maybe, but you want to come into a trial with a theme, and you want to stick with that theme and that narrative, and surround all of your witnesses and evidence and cross-examination around that theme. This could have easily have been the theme of, this is a family law dispute where the mother's taking advantage of the situation. And you could have framed everything around that, because then you could bring back in Sadie. You could bring back in the friend in her. Remember how condescending she was? This is a woman who was out to get her kids at all costs. And, you could frame all of that around this. And this is a father who's fighting for his kids. Sure, he's going to have information on Rosalio, because Rosalio's with the mother of the kids. And that's part of the family law dispute, right? So you could frame everything around. You don't have to go into whatever alleged drug use by Sadie, or if that's
Alleged.
Well, I'm assuming it wasn't brought up, so I'm assuming there was probably something pre-trial that the judge said you're not allowed to talk about that, right?
Yeah,
So
the judge said you're not allowed to talk about anything the whole trial. Anytime defense tried to make a valid point, it was either Gravely going objection, or and then
I don't know why the defense would not have used visuals and demonstrative. You got to ask them. I love them because
They should have.
Well, again, we're not all preaching to the same type of people, right? They were talking to a juror like me, but there's not everyone is like me. So other people are like visuals. Other people like attacking the evidence. Other people want to see some things rather than just the lack of evidence. And to be fair, I think Nicole should have done the closing, because she was the one that did most of the work during the trial itself. It only makes sense. All of a sudden, there's who's this guy? We've never seen him speak. Now, everyone watching from home saw him speak and make some arguments, but otherwise, he was just kind of there. Why is this guy doing the closing? We'll get to that part. But that's just a lot of the issues that I'm having with the trial and the defense strategy. And again, we are seeing this hindsight. We are armchair quarterbacking this a little bit. So I want to be at least fair to the defense that way. We're not sitting in the room. and spending a couple of years prepping for this. But I want to get to these statements, right? So we have two witnesses that are not available. And just like day one or day two, I can't remember what it was, the defense decides that we're just going to issue statements. We're going to read a statement to the jury. Don't worry, the jury's going to be able to take this piece of paper with the statement on it. Jury's never going to look at it. But there's two important things that came out. One is that the surveillance videos were looked at and nothing of significance was discovered. Presumably not Zach, not Zach's van, right? Okay, great. You read a statement to me. I forgot that. By the time I get back to the jury room, right then, I forgot it. It's not as impactful as having a witness sitting on the stand saying, I looked at these cameras, I looked at these cameras, I looked at all these cameras, looked at that one over there, looked at that one over there. I spent hundreds of hours looking at video. You know how I know it's hundreds of hours? Because I've been downloading the damn things. So to sit there for hours and hours and hours and not see anything and have him on the stand saying that is more impactful than just reading a statement. And the other one, the second one, is even more important because it is used to contradict a lot of the statements that OA says. And it's just, I forgot about these two stipulations until I just watched the trial today. I completely forgot they even existed. But the second one contradicted so many things that OA had said on the stand, and they were just sort of rattled off for the jury to remember, I guess, or care about in some way, which they're not going to because you're just reading them a list of things and moving on. So I have a problem with the stipulations.
I agree. I think that it was really it's even questionable that Anschutz was out of town. I have no idea. I don't know him personally, but could he have been in town for it? He knew that he was going to be called to testify.
Mm-hmm. Yeah, of course he did.
There was no way he was going to stick around for it. He knew that what was coming, and he knew that he looked terrible on the stand. There's no question. He looked terrible on the stand. So of course they were going to want him back. I still think that the defense they shit the bed. They shit the bed by not calling Sadie back. Sadie should have been called back. Absolutely. They should have called me to testify. They should have called Sadie to testify. And like you said about the previous day of trial, they clearly didn't even prep their witnesses. And this is something that, it was very clear that they didn't even prep Zach because Zach is unsure about whether he's going to testify. He doesn't have that situation, and they have to discuss and take a recess to discuss it because it's a problem. And so what is the defense doing? They're not doing their job. And like we talked about, they were overconfident in the evidence itself or in the lack of evidence. And that was a problem. But regardless of their confidence in the evidence, they still did not do the bare minimum, which was prep their witnesses, for Christ's sake. And so we have a major issue with this. And then we have, on top of that, we have the money that goes missing and all the other stuff that were issues with what the defense did not do, negligently did not do. That all comes into play. But we have today, more stipulations, fewer witnesses than they should have called. When I was told they were going to call Gravely to the stand, and I think they should have. I think they should have called Gravely to the stand based on multiple witnesses and multiple statements made by Gravely, because they could have submitted, as we discussed on the public record, for the mistrial. He says, here, let me quote this because it's obnoxious.
Yeah, that was the other thing too. I was waiting for Gravely to be called. We were
so
teased. It's like a gun in the opening act of a movie. You're like, oh, that gun's coming back, and damn it, Gravely never took the stand. It was a letdown.
Well, every day that we were present, they were still telling us, oh yeah, we're calling him. Oh yeah, we're calling him, because we kept asking, like, when are you gonna call him? We're waiting. And then they just didn't.
I think it's
and they didn't call Solomon.
Anything.
Zenith, were you on the witness list?
No.
Probably could have
been. You lived out of state, right?
No, I was there at the time. I had just moved to Wisconsin the weekend of OA's birthday.
Oh, okay.
So I was there for that. Yeah, like I was there on her birthday. I was
Yeah,
there.
you could have testified that he was in her house.
Yeah,
on
and
her
that
birthday.
and that we didn't invite ourselves over, and that it was definitely like, yeah.
Yeah, rebuttal witness 101. Witnesses
Yeah.
lying on the stand. Here's a contradictory statement.
Yeah.
And when you're rebutting a witness for the credibility of the witness, it doesn't have to be something of material fact. It can be something of insignificant fact, just to show that they essentially went up on the stand and lied about anything is enough to discredit them. So so calling someone like Zenith just to say, yeah, no, we were there, we didn't invite ourselves, we were invited over, we were in the house, everything she said about that birthday party was completely wrong.
Yeah.
That would have been enough just to, rebut part of her testimony, which is essentially what was done with Mr. Washington in calling McAtee. Because he wasn't saying everything that Mr. Washington said was absolutely incorrect. He was just saying, hey, he went up to me and he said, hey, you want a deal on your Fed case? Then make a deal with these state guys. Come up with something, and that's enough.
But like, do you think anybody listened to Washington and was like, that guy? Like, totally.
That's what I said. I said he was not convicted because of Washington's statements. Oh my God.
That guy's credible.
Yeah, like,
end of case.
Like, I didn't think he did it until I heard that guy say he did. Like, I don't know.
But I believe the jury believed Sadie. I mean, they had to have to, and she wasn't believable to me.
I didn't find her believable at all, and I know her.
I don't know her. I don't know you guys at the time I'm watching this.
I feel like even if I didn't know her, you could definitely get her attitudes just from like the very professional, like, yes, no, here's the answer you told me to say, this is what we're gonna say here. So when it was whatever it's called, when the defense does their thing, and it was just like, yeah, whatever.
I did answer.
Yeah,
Thank you.
Oh yeah, and then she got shitty with the judge.
Yeah.
She got shitty with Schrader. I did.
Now Josie makes a good point that the jury probably believed OA, and I do believe that OA's testimony could come off as a little bit more, definitely more credible than Sadie's, and that's why again the introduction of the stipulated statements is so bad. You want the witness on the stand saying these things that OA testified to were absolutely incorrect.
So I do want to point out one thing here that is a really important piece of this overarching narrative, and that was something that I was about to read. And this is Gravely, right? So Gravely in the mistrial, the first trial, says, quote, so Detective Correa, the primary detective in this case, outlines the blood findings based on his training in some detail at that early stage. I asked, though, because I knew at that point that Officer Van Wee was going to be the person. I said, I need you to reiterate this. I need you to put this in a report so that the defense has the maximum notice. And I insisted. He goes on to say, when I made that decision, I asked them to immediately generate a report. That report is a parallel report to the report that Detective Correa did in his original report. Those are his words. That is him admitting that he told Officer Van Wee what to write in his report, so it matched Correa's report. That is a DA telling a police officer who is one of the lead investigators that he needs to write a report in a certain way to make sure that then Gravely, when he's prosecuting the case, has something that he can argue. This is not inside the scope of practice of a prosecutor.
Right. No. No, I mean, I don't know what else to say other than, yeah, you're correct. Procedurally, this case was a disaster. And from the defense standpoint as well. But Gravely has a lot to do with this. Even Was it today? No, it was yesterday. Yesterday was such a gravely day. Oh my god, he couldn't ask a freaking question and it was
Oh,
gravy.
he
Yeah,
could barely
he couldn't ask a freaking question.
The entire case, David. It wasn't just yesterday. He
I know,
couldn't
but it
help
was
himself but to ask leading questions.
it was so much of him yesterday. Oh my god. All right, so what we have is essentially ending on the state's last rebuttal witness, the second rebuttal witness, who is the corrections officer. Solomon got that wrong, the order. And we already talked about him. And then we go into closing arguments. That was it. That was all of the defense. The
There was
defense
one thing in between. They go into a lengthy discussion of what the charges or what the like they go back and forth about the
jury
issues
instructions.
with, the jury instructions and everything
Mhm.
else. So they do go into that before they recess for day 14, because then they're supposed to submit the jury instructions to the judge in all of the charges, and then they
By
litigate
5
that
or
over.
6 o'clock Sunday night. I can't remember which time because
Right.
they said 2 different times and they never confirmed which one.
Right, and they still messed it up somehow because then on day 15, Trader starts the day out and he says, "Well, I told you that I was giving one set of instructions for the same charge for the 2 different victims, and you gave me
Yeah.
multiple instructions." And Jessica has to like backpedal and apologize to the judge and scrape and bow.
Yeah. It was just why the jury instructions weren't produced before trial. I'll never know. But because normally you produce those things ahead of time. You produce all of the jury instructions and then they're segmented. There's jury instructions you read before voir dire. Then there's jury instructions you read after the jury is impaneled. Then there's jury instructions you read right before opening statements. And then there's jury instructions you read after right before closing arguments, and then more jury instructions after closing arguments. But they're all that's usually set up before you even start the trial. Again, this should be a pre-rehearsed recitation. Like everybody knows what's going on. Why we're still arguing about jury instructions right at the closing of the case is beyond me. I don't get that. Procedurally, this case was a disaster. I don't know if that was normal in the court, but it doesn't seem that it should be if it was. But yeah, so closing arguments start with the state, and then the defense goes, and then the state gets a rebuttal. And rather than going through all of the state's closing arguments, this is our episode of The More You Know.
So your hand, maybe get a little arterial spray, some blood, maybe the steel-toed boots now maybe you're in a dark location, maybe you can't. So maybe you are finding that plan A is not going to be exactly workable. And so maybe you didn't have the tools, maybe the personal clothing that you are wearing. Maybe you are, and so maybe you didn't, maybe, in fact, you might burn your jeans and we find some buttons. And in fact, you might even burn 2 pairs of jeans, right? So you might even you might even need to burn multiple pairs of jeans. Because on the evening of the murder, and confronted on cross-examination, is murdered on May 17th, 2020. His body's found on May 19th, 2000. His body's found on May 19th.
Maybe his body was found on May 19th, and they just aren't telling us. But that's essentially his closing. Maybe this, maybe that, maybe he burned 1 pair, maybe he burned 2, maybe he went in by himself, maybe he drug him out in the rug, maybe he hid him somewhere on the farm, maybe. Oh my God, so many maybes. That's not beyond a reasonable doubt. That closing argument alone is not beyond a reasonable doubt. Zenith, were you there for that?
She's muted.
Yeah.
Boomer.
Was I there? Was I there for the closing?
Yeah.
No, I only made it to sentencing. I was back in Texas by the time the trial took place.
Okay. I was just wondering what you guys were thinking when this was going on.
I mean, it was
Ugh.
ridiculous.
It felt like a fairy tale. And I actually, today I went through and I was reading the transcript of his closing statement. And the other thing I wanted to point out is that he used the word innocent 36 times. He used the term falsely accused 36 times. And he used bad luck 36 times, and he used falsely accused 40 times. So he asserted innocence or falsely accused over 100 times in his closing argument.
That was a theme during sentencing too, that we'll get to, because that was addressed during sentencing. Is he claims bad luck and falsely accused, but he claims that for every charge he's ever faced over the last 30 years. The way they phrased that all, and it was a nasty way to approach this. But we're not there yet. We still
think
have.
There was actually one really important part of Gravely's closing argument that I've brought up, and that is when Gravely makes the reference, the inference to Zach's right to silence. This is really important because in the instructions that Schrader gives to Zach when he's explaining to Zach the right to testify and the cross-examination, what to expect, and all those things. It's part of the normal court proceedings. He informs the defendant that he has the right to testify on his own behalf, but then explains the risk of that. In that, he says that if he chooses not to testify, then the prosecution is not allowed to comment on it, period. But what do we have in the closing argument? We have Gravely say, well, he had the opportunity to clear things up.
Yep.
So we then have him intentionally making a reference to the right to silence. This is not a mistake. This is not something to split hairs about. He intentionally attempts to walk the line by inferring, but he absolutely violates Zach's Fifth Amendment right to silence by trying to manipulate the jury into a conviction based on him not testifying. That was
the last case that
the
last case that I watched with this judge and someone trying to invoke or use against them the right to remain silent elicited this response.
Don't get brazen with me.
So where was this judge? That's from the Rittenhouse case, by the way. Where was this judge, in this exact situation? He
bonked his head.
Yeah, that particular piece of brain matter got left on the floor, I'm sure.
Apparently.
But I did want to say that now this is the perfect time for me to say this, because there was a point I wanted to make about having Schrader on for this trial. Because everyone, wants to give him shit or just like how he shouldn't have been or whatever. But I was thinking about it tonight, actually, and had Schrader not been the judge, Zach might not have gotten the attention, that he ended up getting, because people wanted to watch another Schrader trial. So
and this was interesting because Rittenhouse wasn't the first time Schrader had a nationally publicized case either. In fact, he just had the Mark Jensen trial. Well, not just, but it was like 2005 or something. And so that was nationally televised as well. So this is the judge that's known to do that. I haven't seen any other judges out of Kenosha, Wisconsin that are being streamed anywhere. So that's a very true statement.
In 2023, in January of 23 was televised. And the reason why it was because of the attention that it got in 2005. So it was appealed and retried in 2023.
Yeah, you're right.
And then the cameras were actually still in the courthouse following Jensen, and they were like, "Oh, well, we're here. This case seems interesting enough." So they actually streamed Zach's trial too. It was a big lead into it. Zach was in jail with Mark Jensen.
Well, when was Rittenhouse? Was it Jensen, Rittenhouse,
19?
Zach?
Well, original Jensen was 2005.
Yeah.
Then Jensen was tried again in 2023. Rittenhouse was like 19, I think, 2019.
No, it was 2021 because it was
21?
after
all the
after he was charged.
Okay, so I stand correct,
It
but
was
either
the
way,
summer of love. Okay.
so either way, Rittenhouse was well before that, and regardless, it's still a situation that took place during this time period that Zach was incarcerated, but Schrader himself has a clear cognitive decline between just between Rittenhouse and then Zach's trial, and if you compare between Zach's trial and Jensen's trial in 2005, he's like a totally different human.
Yeah, he was. And I thought Jensen was a lot longer ago because of how different Schroeder acted in that case. Because Salvador Dali's been streaming that. And I was like, oh, this is he's like young and spry. So that's interesting that so much damage was done from that head fall. So yeah, okay, Rittenhouse 2022. That makes more sense. All right. So I wanted to contrast just why I feel like defense closing argument was so bad. The jury had never heard from this guy. I don't think they've ever heard from this guy.
He did arguments litigation with the judge, mostly without the jury present. He might have said like 2 sentences in front of the jury.
Yeah, but this is
there. And incidentally, later that day, he goes to pick up his taxes. Is this what somebody does when they've just murdered somebody the night before? Just going about doing normal things, normal business, normal work. Now, one thing about this case that is utterly hard to explain as to why this occurred and why law enforcement.
Oh my God. Painful. We had no idea that he
counter going, I think, first. Huh?
So
we had no clue that he was going to be doing the closing. The three of us were texting each other like, what is happening? Why is he doing the closing? Where's Nicole?
We didn't
messing
have
with his
any
hair
idea
coif.
why Kirk did it.
I just that's what I noticed is the messing with his hair. It
So
was distracting to me. I wasn't listening to him. I was just looking at his hair.
oddly enough, a lot of the talking points that we've actually had, even on this program, a lot of the issues that we've had with the testimony, with the issues in the case, with gravely misrepresenting facts in his closing, Kirk actually brings it all up. He actually talks about it in his closing argument.
He does.
But the issue is that it's the way it's organized and the way he presents it is not impactful enough, where he starts out by addressing the facts of the case, and that's like the start of it. He kind of goes on about it for a long while, and then he gets into the reasonable doubt afterwards. I feel like it really should have been the other way around, and it needed to have more passion and less hair flipping.
Yeah, and you don't want to just list the facts, right? You don't want to just list facts. It's like the stipulated statement. You don't want to just list them. You want to tell a story. You need to tell a story to the jury that's going to engage them, that they're going to follow, that's going to make sense. It's not going to confuse or
you
bore
need to
them.
spell it out.
It's showmanship. There's a reason why, so they tell me, there's a reason why people listen to me. Apparently I can talk and it's in a compelling way, right? So, but you need to be compelling to the jury. Otherwise, they're just going to ignore you. They're just going to forget what you said. It's just like reading from a script or reading from a stipulated statement. If there's no passion or story behind it, no one's going to care. And that's the biggest problem with him. He might have been hitting all the facts and hitting all the points, but nobody cared.
Right. And Gravely, unfortunately, had a better story. He had a more fantastical story with all these things happening. And so, I mean, how many people have we seen that have commented that that's what sold them? Oh, I was unsure until I saw the closing. Like, oh, hypothetically, let's just call somebody Dandy Doog. People like that out there that like, that's what they believe. They're like, oh, I was totally sold on closing.
Well, what about the fact that okay, so Nicole starts her opening whichever time that they actually did. Is it the third or the second? How many times do we have to start this trial? 2 or 3? 2, 3?
Twice.
2. So the second one, when they almost called another mistrial or tried first, I think it caught her completely off guard, and it kind of snowballed from there as far as how the rest of the trial went. And then how do you defend someone and say like, my client didn't do this, but you're not allowed to say somebody else did.
Right.
Like, all you can say is they didn't do it.
Just believe me,
such
they
a-
didn't do it.
Like, I
Yes.
don't know.
Why is Wahala here? He just popped in the background.
Hey, I was just trying to help y'all out and let you know
Oh, hey.
that you're going a little long.
I know. We said we'd go long. Jen wanted like a full 3-hour stream. I said no to that.
Well, I just said we
That's
could
right.
talk for 3 hours. I didn't say we had to. I just said there's a possibility.
I wasn't prepared to be on camera, yo. I wasn't prepared.
You pop in the back
Well,
room, you go up on camera.
Just
Very
um,
well.
As long as you don't stand up not wearing pants. And I don't care
Well,
if you're wearing
that's-
pants or not. I just don't want you to stand up.
That's why I turned the camera off for a second there to turn on that light up there. Yeah.
But I'm completely forgot what we were talking about.
We were talking about
Oh,
Well,
I know what I
it's-
was. So based off of
Closing and
Zena's
how
statement,
terrible it was.
yeah. So the Denny motion, this idea that you have to convince the court that you have substantial evidence that some third party did something before you can start pointing the finger is ridiculous to me. It's been shot down by the U.S. Supreme Court. I don't know why it hasn't been fixed in Wisconsin. If a defendant wants to come in there and say space aliens landed with a crystal skull and committed all these crimes, so be it. The jury doesn't have to believe them, but they have a constitutional right to argue
David,
that.
did you
And I
just
don't
say
know why.
that Shia LaBeouf was the killer of Rosario Gutierrez?
He might have been. He might have been. There's at least as
Maybe.
much evidence as
Yeah, I mean, we don't know where he was
Zachariah.
on the
Wait,
17th.
what was Shia LaBeouf's phone activity on May 17th,
exactly.
2020?
He was
If
sleeping.
there-
Now,
if
I
there's
think
a
he was
gap in
standing
phone
in a corner
activity-
in New York on a webcam, so he's got an alibi.
Crap.
But yeah, no. So the Denny thing is completely ridiculous, and I think that's what you're getting at, Gina. This the ability not to be able to point the finger at somebody.
Well, I mean, and
Um,
just as far as the closing goes, I don't know. I don't know. I
So-
think it was interesting that they spent 3-ish years with Zach and this case, and it felt like they didn't know it like the back of their hand, you know?
They should know it. As a defense attorney, I immerse myself in the case. There's a reason why, like I said, I retired from YouTube. I said I was going to. I had 4 trials coming up, and they were all a month apart. But it takes me a month because I completely dive into a case, and I know everything about it and where every document is and everything before.
Except the names.
Except the
Can't get
names.
the name.
No,
Or
the
the
names
spelling.
are irrelevant. It's him. It's her. It doesn't matter. Well, even if you saw my my MLS goes to court stream, which I'm gonna have to put back up now. But there's a point where I'm literally flipping through documents trying to find my exhibit. I'm still able to ask questions. I give my opening and my closing arguments with no notes because I know the freaking case inside and out. And while this case you should probably have notes because it's more intense than mine was, still you should be so immersed in it. You know all the players, you know everything. You've talked to everybody, and it was clear that they didn't.
Yeah.
How much of that though is because of Gravely's dirty
hang on.
antics?
A lot of it is because of Day's.
It's got to be, right? Like
Yeah.
with somebody just throwing that much filth into the
Yeah.
case, it's got to throw you off your game. It's
I
got to.
feel like just feel like they didn't do their own investigating enough either, though. Like, granted, yeah, it's supposed to be the burden of this or that or whatever, but like, if they had just taken the time to talk to us, I had never talked to Aubert Nicole personally. I know Zach complained time and time and time again that he didn't get to talk to his lawyers enough about anything. Like, I don't know. It just seems messed
It doesn't
up.
matter about talking to their lawyers. A lot of people say that. Sarah Boone says it all the time. My attorney's not talking to me, but your attorney's still working on the case. Your attorney's
Right.
pouring over the you are not necessary for.
If I'm sitting in a jail cell stressing about my case and I want to talk to David so that he understands how important it is to me that he gets me out of this situation that I'm in, believe me, there's not enough time in the world for me to talk to David, right? Like there will never, like I did not talk to David enough, no matter how long we talked. It's just
I
not
have a
going to be enough
client like that right now. Right? I understand. Every time he calls me, it's going to be a 20-minute conversation because he wants to talk about stuff that's not relevant. Try to steer him back. But in the meantime, I'm still working on his case. There's a running joke amongst attorneys that the practice would be awesome, but for the clients. So if we can just somehow
Much like
figure out to
healthcare.
get rid of the clients.
That sounds completely accurate. Actually, that makes perfect sense.
I
to me.
mean, it does make sense. I love my brother, but he frustrates me to no end. So we really are brothers. It's a thing. But the reality is that, I made a reference earlier that it really did appear in the court when watching it live, that Zach wasn't prepped for even testifying. And regardless of your point, David, if the defendant isn't prepped by his attorneys to testify just in case they've got a Hail Mary and put above.
Well, that's different. Yeah.
If they didn't
You
plan
need
on
to
it.
go over that potential testimony because it's still up to the client. And if the client says, I want to testify, you need to have that testimony ready to go.
Yep. Then they
I would assume though that they had decided long before that wasn't going to be the case, right? Like I'm sure that they
Doesn't
had
matter
talked
about
about
that.
it.
It
Maybe
doesn't
not.
matter what the
Maybe
what
not.
the-
Doesn't
what
matter
the
what the
clients
lawyers
want
say.
or the lawyers
Maybe
the
not.
defendant has the right to do it. So if
Yes.
if the
1000% yes.
100%.
Don't yell at him, Saul.
If the defense attorney
Leave him alone.
did not 100% prep him for the potential of testifying on his own behalf, if he felt that he should do that, it was their role. They were retained to defend him and prep him for that potential eventuality.
And you can see that when Schroeder asks him the second time around, have you consulted with your attorneys? You understand I'm hearing from them that you don't want to testify. And he says, I have some questions for my attorneys. I'm not quite clear on a few things, but I'm not going to testify. So that seems to be, that was an odd thing to say, why you would still have questions for your attorneys, even though you're affirmatively making a statement that you're not going to testify. So we have the state's rebuttal, which is more of the same. Maybe this, maybe that sort of thing. It's really not a cohesive story either, although it's a better story, I guess.
I do want to point out that Gravely went over on his time by like 15 minutes.
20.
Or 20 minutes.
Schrader clocked him at 95 minutes.
Yes.
Which is why What's Your Nuts only got 10.
So the rebuttal was supposed to be short, but she went over her time too anyway, and he did nothing. He didn't cut her off, nothing. He just let her finish no matter what. And this is part of the issue, right? Is that Gravely goes over. And for the record, he spent like almost 15 minutes just talking about the jailhouse snitch discussion and trying to discredit McAtee in that closing argument. So he spends like 10, 15 minutes of his close where he's convincing the jury that Zach is guilty of a crime, that he is innocent of a crime, that Gravely himself didn't do something, which isn't actually part of the case, but he wanted it on the record.
Oh, absolutely. He's way more concerned. Gravely was way more concerned about his reputation in that aspect than he was about anything else.
So, yeah, no, definitely. And I know we agreed to go over, but I'm still going to keep us moving, Solomon. So, all right. So we get to sentencing, right? We have the parade of victims, that
we get verdicts.
expect.
You skip
We get the verdict. Well, he's guilty on all counts. I mean, we got that.
I mean, it's important. We're summarizing the stuff.
That's true. That's true. Yeah. So after how many hours of deliberation was it?
10.
It was like 10.
It wasn't
10 hours.
enough.
It was not enough.
Two questions for the lawyers, and there were no answers provided to the jury to answer those questions during that deliberation.
That's right. Yeah, because they were. I can't remember what the questions were. I have them in my notes.
It was like the date and time that things were downloaded to his computer, I think.
Oh yeah, and it was user memory of the testimony, essentially, which is appropriate. That's an appropriate response. So I have no problems with that. And then we have a verdict, guilty on all counts. Zach looks shocked. You could hear a little bit of noise from the crowd on the other side of the aisle, I should say.
Mhm.
And yeah, and that was about it. And then what was it? 3 weeks later, we had the sentencing.
May
4 weeks later?
16th, after he was
Two-
convicted.
2 months later, almost 2
27th.
months later.
So
Was it that long
like,
ago? Okay.
Yeah, it was like 7 weeks, 8 weeks.
I was trying to think of the timeline. So I would have been in the middle of another case at that point. But yeah, so we have the sentencing. Rosalio's mother speaks, his kids speak, Sadie speaks. The problem I have with the whole state side of the sentencing is, to me, even if I'm looking at this objectively, it's not clear what happened, but everyone is so certain that this is the most evil person in the world, the horrible things that he did. And Judge Schroeder had a moment where he said, "You've been found guilty." He said it like that, and this was before he told Zach to stop shaking his head. You've been found, and kind of yelled at him about being found guilty. But he said it essentially, you've been found guilty. And as opposed to everyone else who was like, you're absolutely guilty of this heinous crime. When it's not clear for me, he had even met Rosalio in person ever. The meaning behind the colder weather thing. Oh,
No one knows.
part of the Sadie testimony or part of the Sadie impact statement. But I was going to
Yeah.
let you finish before I brought it up.
No. Go ahead and bring that up.
Well, hold on. You were talking about what was the beginning of that?
It's talking about the judge saying that you've been found guilty, which means that the judge.
No. Okay, there you go. Thank you. So the victim impact statements, the people are blaming him as being the worst thing in the world, but that's what they have to point to, right? So I would like to avoid some of those victim statements a little bit, like especially like his kid, right? Like,
Oh yeah.
okay,
Yeah.
so yeah. According to him, the guy that got found guilty is going to be the most evil person in the world. I get that. I understand where that little kid's coming from. Let's let that slide a little bit, right?
Yeah.
But when it came to like Schrader, and that little tongue wagging at the end there, right? You can wag your head all you want to or whatever.
Yeah.
That was completely unnecessary, uncalled for, and there was no reason for Schrader to dig into any of that.
Well, Schrader was all
very
about
unprofessional.
getting into the Andersons that day.
Oh yeah, you got tore up for no reason. That was another thing that I found absolutely
what the
ridiculous.
Like I don't think I've ever been as embarrassed in my life, and I've done some pretty embarrassing things in my life. But
What is this all about? Horseback riding? Why do I need to know about this?
Music and horses. God.
Yeah,
that was completely unnecessary and a
I was so
complete
stupid.
total asshole move on Schrader's part, in my humble opinion.
I was like,
What he didn't even recognize or care was that there's a rubric that they send people to write these letters, and in the rubric, it specifically tells you to write a little bit about yourself and then go into all of this stuff.
Make sure you introduce yourself and like a little bit about you.
Well, that's why I think that this was so egregious, because I'm sure that Schrader did know that, or at least at one point did know that, right? He intentionally picked out certain words in those letters and displayed them. Whether or not he would have done that before the head injury, I can't say for sure, but I thought
he claims that he never let people, speak on a defendant's behalf, and then he recounts that and says, "Well, on rare occasions I do."
Right.
But he also states that
that's a fundamental right of the defendant to have people speak on their behalf.
I mean, I agree. He claims that his interpretation of the law says otherwise, and that because we're technically not victims, that we don't have the right to speak on his behalf. And in his opinion, it's not part of the individualized sentencing, so he couldn't.
Did Jensen have family speak on his behalf at sentencing?
Yeah, his sons, I believe. So yes, he has let other people do it, even though he claims that he hasn't. And furthermore, when Nicole brings up that I was prepared to speak and that I had written a statement to read to the court, he then says, well, I don't have the letter here. And
it's a prepared to statement to read to the court, not for the court to read.
Exactly. And that was one of the issues that I had with it. And I was just sitting there boiling, knowing
he was like, it was bad.
He had seen me. I think I was shaking. I was so mad sitting
You were shaking.
between the two.
Yeah, I was like patting his leg. I'm like, stop it. Don't get arrested.
But he literally saw us standing outside by the stairwell in the courthouse. And he saw that I was wearing an FCA shirt. And he walked up to me and he looked at me and he said, you're going to have to cover that up or take it off in order to enter the courtroom. And I said, no problem. And I closed my flannel. So he knew that I was wearing an FCA shirt, and he knew at least where my opinion was coming from. And then he intentionally refused to let me speak.
Well, yeah, he wouldn't let us wear our shirts in support of Zach, but Rosalia's
I
family
remember
can
that
all wear,
for
like,
sentencing.
his face on
I
our
got to wear
shirts.
Cubs stuff.
Yeah, I was doing a little group stream, and I remember we were hearing rumors that people were being asked to leave the courtroom and things like that.
Yeah, that we were causing a ruckus because.
And also completely
I don't know
false.
what we're
All the
doing.
FCA supporters that were there were completely peaceful and completely respectful, very polite to everyone wearing Cubs, gear and all the things that they were doing in some symbol of solidarity, which was acceptable to the court because that was normal clothing or not special clothing or whatever. But they were all allowed to do that. Nobody had any issue like that about any of those things, and nobody made a stink about anything. So all of that was fake news.
So, Miss Cave Troll, I need to ask you about the cold weather statement that Sadie made during her.
Oh yes. So at the end of her statement, what did she say? She said something to the effect of,
"Just waited for colder weather."
Yes, you should have waited for colder weather. And everybody has been wondering what this was. And so going through the discovery, I actually figured out what this was. Zach had sent her an email at some point that said, check out this song. It breaks my heart. It made me cry.
So
and
it
so
is.
she
Is
specifically.
it Zach Brown Band?
Huh?
Is it Zach Brown Band?
Yes. Yeah, it was the Zach Brown Band Colder Weather song. And he said, this song breaks my heart. It really gets to me. It made me cry. And so she references it, I'm assuming, because she knows that it's going to be like a gut punch for him.
So if I recall correctly, the lyrics to that song are something along the lines of, I'm stuck in colder weather. Maybe tomorrow will be better. Can I call you then? So for Sadie to quote that song in that instant made it seem very much like when she said you should have waited for colder weather, she misquoted the meaning of the song because she's kind of stupid. But
yeah, 100%.
What she tried to imply was that maybe we could have worked this out later down the road, implying to me that relationship was not in fact over. And that was not Sadie moving on to live happily ever after with fucking Rosalio Gutierrez, blah, blah, blah. That was very much her reaching out to Zach in that moment.
Again,
and still trying to manipulate and influence him in some way.
100%. It absolutely was.
The most important statement of the sentencing, I think, is this. And I think this is this kind of says it all, this minute or two.
That's it. And if I killed somebody, whatever that situation was, I can tell you in my own heart it wouldn't be intentional. If I didn't at all, the guy I never met, I don't really know what this is, but I didn't do it. I'm innocent, Judge. Not guilty. I'm innocent.
And that is what this case is about. Now, someone asked me, my wife asked me if actually Solomon too, a few weeks ago, if I thought Zach was innocent, truly innocent, or if it was just like a system issue, right? I've never thought Zach did this. Even watching the trial to begin with, I'm like, it doesn't seem possible, physically possible, with all the information that was being presented. But the more I dig into this case, and the more I've met you guys, and the more I've never actually spoken to Zach, but the more evidence that I've gathered that wasn't part of the trial, I believe he's innocent. And someone had once had commented on one of my streams. I don't know if it was this stream or an earlier one that said, I'm tired of hearing everybody was wrongfully convicted. But this is truly one that I think it's a wrongful conviction, not only because the procedure was bad, which is where I stood from day one, but because I truly believe this is an innocent man.
I will 1000% stand by the statement that this is a wrongful conviction. I don't know if he's innocent per se, right? I wasn't there. I don't know 100%. Doesn't seem like it. Sure the hell doesn't seem to add up in the state's case. And in no way, shape, or form, in my opinion, did the state prove that he did this. So he should absolutely be not guilty. Whether or not he's innocent, I can't say. But I don't believe that he should be guilty. 1000%.
Yeah.
Well, and I will say that, the whole time, we've known he was innocent, but I can tell you that looking through all of the discovery, now that we actually have all of it, it is egregious the amount of exculpatory evidence that they actually had in their hands and completely ignored. It the hours and hours of recordings of Sadie and Zach in their own words talking about all of these, every situation that they brought up in court, they are talking about it on these recordings, and he was smart enough to record that stuff, and they have all of it, and they just pretended like they didn't, and it's now it's just even more mind-blowingly bad seeing the rest of it, and I know Saul and I are so eager to get the rest of it out there when we obviously have permission, but
I've got
bad.
a lot. I've got a tower of discs that I still need to get through, and I'm like I said, I'm gonna, as I get stuff like the 911 calls we put out there and other things, as I get stuff, I'm gonna try to put it out there as much as I can, because I'm under no constraints. They gave it to me. I'm gonna publish it.
Yeah.
So if it's something relevant, the surveillance camera from the school, the 20 hours of surveillance video from the school that I watched, probably not going to publish that unless you guys really want to see it. But things that are relevant. I need watch hours on my channel. I might just throw it out there.
I really think the biggest thing that tells the story is the text messages. That is what I want to be able to put out there. Sadie's text messages, Rosalio's text messages, there was a lot of stuff happening that nobody could see. They can't really show all of the context, but there's a lot of stuff happening that's really questionable.
I have another discovery request going out to the court for all of that stuff. So I should have that back again soon.
I almost texted you today and was asking you about a FOIA. I almost did it.
Yeah.
So,
you wouldn't be the only one. I get Salvador's always messaging me. He's like, I want to FOIA this, or I want to do that.
So we have the verdict is at the end, in summary for the day, that he got 50 years and they took off time served. So he was due to be released cumulatively at the age of 89. So with no possibility of early parole, nothing like that. Though I think that there's potential for medical issues that would then get him released from prison earlier than that if he deteriorates in health.
Yeah, the judge even says jails don't want to take care of old people, so they release them early.
Yeah, exactly. And so this is the thing, is that Gravely makes this argument about maybes. Jessica smears him in sentencing and talks about how, it's never his fault, which is not actually true, because then the defense even talks about how he owned up to the mistake that he made and accepted full responsibility for it just 2 years prior. And that was really where he was at in his mental state. And in this situation, we have all of these lies, all of this exculpatory evidence that the state had, that the police had, videos of child abuse, recordings of it. Now we have mandatory reporters not fulfilling their duty to do it. We have Gravely telling the police what to write in their reports. We have defrauding the court and defrauding the jury by the prosecutor, both of them. And so we really bring this back to this full circle of the bad man argument. What Oliver Wendell Holmes says is that the bad man is someone that does something maliciously to avoid consequence of their bad action. And that's what we have.
And it's exactly what we have. We have a situation where the courts have allowed prosecutors to circumvent the law.
Not allowed, encouraged.
Mhm.
It is brought on a culture of necessity where prosecutors must find convictions above justice. They must have win percentages, and some of these low scumbags will revert to dirty tactics to ensure that happens in order to progress their career. Gravely is the prime example of a man that is motivated by achievement above morality or anything good for the world, right? He is purely motivated by his own narcissistic will.
Mhm.
Well, at the end of the day, too, you can have a narcissistic bad man as a DA. You can have a incompetent elderly judge. You can have deficient defense counsel, but you still have to convince 12 members of your society that what the state has is proof beyond a reasonable doubt that this individual did something.
Which
And
is
I
hard to
blame the
do when
jury.
one of them is sleeping half of
Well,
the time.
I blame the jury as much as I blame everyone else in this situation.
I
And
disagree
the jury is
slightly.
made up of us, people, us, society.
I
Everyone's
disagree
watching.
slightly.
Well,
I
you're
think
wrong. Slightly.
If you take Gravely's out of context and untrue statements out of the trial completely, I find it very difficult to believe that 12 people would have bought into this. Without Gravely saying bleach 1,000 times, without him identifying blood that belonged to Rosalio when in fact that is not the case, without him stating that they found a body, I find it very hard to believe that 12 people would have bought
Where
into
were
this
the
conviction.
objections? Where were the objections? Was there a motion
I don't
to limit
disagree.
to say don't say the word bleach because there's no bleach involved?
I don't disagree.
I mean, I would also say that I would think that anybody that I ever talked to, especially like in the beginning when this was all going down and I was calling like my friends, like, you're not going to believe what fucking happened, you know? And throughout the process of it, it was like, well, you know, it was almost like they wanted to, like, they couldn't, first of all, believe what was happening when I was telling them, like, in real time, because it's so unbelievable. But also it's like, how do you, like, well, why would they arrest him without some sort of evidence, right?
Yeah, that's always the question. How did that happen?
How could this happen if there wasn't something, right? Something. And
that's how that's a societal sickness.
Yeah.
Men like Gravely require that belief to exist.
And that's what they bank on. And that's what the jury, unfortunately.
And the jury is going to sit there as members of the society saying, well, they wouldn't have charged him if there's not something.
Exactly.
So unless he convinces me that he's innocent, he's guilty.
Right.
That's a societal sickness.
During the voir dire, that's basically what the judge told the jury. Is he told them, well, there's a reason he's here today, and it's because everybody thinks he's guilty. And so that's what the judge said to the jury during the voir dire is, well, everybody here is convinced he's guilty, so he's not here for no reason.
All right. That is a wrap on Barely Interesting for Zachariah Anderson. Thank you all for joining us in Zenith and the Cave Troll and Valhalla apparently just backdooring all of us.
That's the way I try to be, bro. That's the way I try to be.
That someone asked in the chat, what our reactions were to the verdict. And listening or watching to this all over again today, to prep every time I listen to this, it's like watching my brother die. You don't get it.
I can't watch the trial again. I haven't watched any of it because it's even more upsetting than the first time. So it's really hard to even sit in on this and listen to it all again, because it's not fun. It's not a good time.
If you are listening to this on rewatch, or if you're watching us right now, pinned at, or not pinned, but in the description below and all of wherever you're watching it is a link to freezachariahanderson.org. You can look at all of the content, a bunch of the exhibits, the cast of characters, but most importantly, you can click right up here and you can go to donate, and you can go down to the Give, Send, Go, donate right here and help with the defense fund. You guys have already, you're $4,000 short of your next goal, which is amazing. So
Outstanding.
if you guys have a moment, please go donate to the Zachariah Anderson Fund. Help fund this. They got Natalie Wisco as has been retained, which is amazing. She's
a rock star, y'all.
She was a rock star. She's been on this channel. She's been on a bunch of other channels, but more importantly, she knows what she's doing. You know her from the Rittenhouse case. And we got to keep this going so that hopefully there will be some justice in this particular case.
This is the first case that I've seen covered. I've been around the law tube sphere for a little while, y'all. Y'all know, a bunch of you know me. A bunch of you see me around for a long time. This is the first case that, like, I stopped being focused on the current trial and was like, hey, wait a minute. There's something wrong with this trial. This is the first one, y'all. And this is the one that speaks to me. This is the one that is the most egregious, in my humble opinion. And it's just, it's messed up, y'all. This shouldn't have been a guilty verdict. It shouldn't have been.
Well, and that's my only final thought, I suppose, is like there is no such thing as justice here anymore. It's completely gone. There is no justice for Zach at this point. So the idea of that could ever be achieved is it's already done. Like, even if he gets out, it's not justice for him. They stole his life. But.
Well, on that, we are going to end. Free Zachariah Anderson as always. Thanks everybody for joining us in the chat. Everyone else, have a good rest of your week.
Yep.